But in order to stay on track and to give Mike Kenneally a chance, I'd like to invite him forward to speak about the road construction, laws, how they're constructed, and how we might work with that. As I mentioned, Mike's got a lot to plow through. You do have a handout from him, so you can follow along as you're going, take notes. He'll be here at the break, and then he'll be here at the end moderating the panel discussion and taking questions, and so you can hold your questions. So then that'd be great.
All right.
Mike?
All right. Thank you for that introduction, Don. Can everybody hear me? All right. All right. Thank you. As Don mentioned, I'm going to just be talking about your options for road preservation, what local governments can do to manage the truck traffic that's going to be coming through their communities. My first two slides kind of just go through statistics. I think we've heard a lot of what the impacts are from Lynn's presentation. I think it's safe to proceed with the premise that heavy trucks making frequent trips are going to destroy the roads, and local governments are responsible for the cost of repairing those roads, and it's expensive. So anybody who's looking for the Cliff Notes version of today's seminar can take the two slides I have on Lynn's materials plus Lynn's two slides that he had on my materials, and that gives you everything that you need to know in a nutshell on that. So moving into then the substance of how to protect your local roads. What tools are available to the local governments? And by local governments, we're going to be talking about towns, cities, villages, counties. Being from the Association of Towns, I'm particularly biased to towns, so a lot of my presentation will focus around the town's laws authorities, but for the most part, a lot of this is going to apply to cities and villages as well, even if I don't expressly include them. Your main sources of authority are going to be the municipal home rule law. That gives you your local law authority. You also have vehicle and traffic law regulations. You have the authority to enter into road use agreements. Most likely, the way you're going to be preserving your roads is by taking a combination of these various authorities. And you're putting them together, and the two major themes here, and I should probably change prevention here, because it's not, what you're preventing is actually not the trucks, but the damage. So it's more preservation and then remediation, because every regulation should aim first to preserve your local roads, protect them from unnecessary further damage, but damage will occur. How do you go about remediating it? So to start with the municipal home rule law. The municipal home rule law provides express authority to the counties, cities, towns, and villages to adopt local laws, and as you saw from Lynn's slide, regarding the care, management, and use of its highways, streets, roads, avenues, etc. Pretty broad authority. Two limitations that would apply to all local laws are they have to be consistent with the general laws of the state, and they have to be consistent with the Constitution of the state of New York. So those are two overarching limitations on your local law authority, but the municipal home rule law does say that as long as it's consistent with the Constitution, as long as it's consistent with the general laws of the state, you have this authority over your local roads. Now, gets into the question of what's a general law. General law is going to be a law that applies to all towns the same way, all cities the same way, all villages the same way. The vehicle and traffic law is a general law of the state, so your local laws have to be consistent with the vehicle and traffic law. Now, this is important because the vehicle and traffic law is preemptive in scope. How many folks are familiar with the concept of preemption? Just show of hands. Okay. Well, preemption is going to come up a lot in the context of natural gas drilling. Many of you have already dealt with this issue with respect to local zoning authority and whether the environmental conservation law preempts local zoning authority. Don had mentioned in his opening remarks that the environmental conservation law says that nothing herein shall limit the jurisdiction of local governments over its highways. So there, the environmental conservation law does not preempt your jurisdiction over your highways. It doesn't give you any additional jurisdiction, so it just doesn't preempt it. So you have to look elsewhere for that. What is your authority over your local highways? We looked at the municipal home rule law, but the vehicle and traffic law does have some preemptive language in it. And when you dealing with a state statute that preempts, pretty much it says that if it's a field preemption, it's saying that these are the regulations set forth in state statute, and there's no room at all for local laws, whether they're more restrictive or least restrictive. If it's that would be field preemption. There's also something called conflict preemption, which deals with it preempts any local laws that are inconsistent with it. So with the vehicle and traffic law, the express language of the vehicle and traffic law states that it preempts all other laws, permits, fees relating to traffic, except as otherwise provided by the vehicle and traffic law. So that's a pretty broad statement of preemption. The vehicle and traffic law is going to preempt all of your local law authority, except as otherwise provided in the vehicle and traffic law. So what is otherwise provided in the vehicle and traffic law? And Lynn had given a taste of some of the provisions. I'm going to go into a little more detail on them. Vehicle and traffic law, section 385, provides for weight and dimensional requirements. You heard Lynn mention this earlier when he stated that state law sets maximum gross weights, weights per axle, dimensions of the vehicles. Vehicle and traffic law 385 is geared towards the really big trucks. These things are huge, and you actually, if you look at 385, you do have to be an engineer to figure out whether or not any of these trucks actually are in violation of what the standards are set, because they talk about weight, how to calculate weight per axle or per square inch of tire, whatever it may be. Chances are you're not going to be dealing with 385. This is kind of the ceiling of the weight and dimensional requirements and would apply to all roads. But when you get into section 1660 and 1640 of the vehicle and traffic law, that's where your local authority is rooted. Now, the vehicle and traffic law 1660 and 1640 set forth a number of different regulations that local governments can take to regulate the traffic on their roads. So you'll see that 1660A10, its counterpart for cities and villages is 1640A10, states that towns, cities, and villages can establish truck routes. They apply to trucks in excess of 10,000 pounds. You can exclude them from all highways that are not on, so you can exclude any trucks over 10,000 pounds from all highways that are not on the designated truck route. So you set forth your truck route. If the road is not on that truck route, then and it exceeds 10,000 pounds, then a truck exceeds 10,000 pounds, it can't travel off that truck route. Two big exceptions. Must allow for local pickup and delivery, and it must provide suitable connection to state highways. And I want you to remember those two exceptions because I'm going to come back to those in a little bit. I wish I had the benefit of one of Lynn's slides on here as an example, but those are going to come into play once we finish going through some of the vehicle and traffic authorities here. So 1668-10, when we talk truck routes, again, trucks weighing over 10,000 pounds can be excluded from roads that are not on the designated truck route. Again, two exceptions: local delivery, suitable connection to state highways. 1660A11. This is one that's unique to towns. It doesn't necessarily have a counterpart for the cities and villages, but it allows the temporary exclusion from many town highways, vehicles in excess of 4,000 pounds or a designated weight per axle, per square inch of tire, whatever the case may be, if it is believed that the highway will be materially injured by that truck travel. And this regulation would take effect. It has to be published in paper. It's got to be posted. So before any temporary exclusions of truck traffic come in, you have to post, you have to publish before they can be excluded. And again, this you'll see it lowers the threshold from 10,000. You can temporarily exclude any trucks weighing more than 4,000 pounds there. Now,
what does temporarily mean?
that's a great question. The temporarily, in its broadest sense, means not permanent. It could be, and I'm not being flippant or facetious by that, but I think it's really going to depend on what the circumstances may be. I think one of the things here, when you compare and contrast these different sections, this would allow total exclusion from the highways. And you'll notice here that it says that you may issue a permit allowing local delivery. So when it says temporarily, I think that it's designed to not be a permanent prohibition. It could be, let's say that seasonally, so that you saw that how the road deteriorates tremendously in March, and that you can have significant damage to these town roads during that thaw period. Well, if you want to temporarily prohibit all truck traffic exceeding that 4,000 pounds during that period of significant weakening, that might suffice. So again, there's not too much out there that really kind of clarifies how some of these terms are defined. I suspect that as this becomes more of an issue, we're going to see a lot more development on that. But one of the big distinctions here, again, is that the local government may issue a permit allowing for local delivery. Now, anybody remember Lynn's sign, the slide with Lynn's sign with the posting on it? Anybody tell me what that sign said? And what was the weight limit? 4,000 pounds, and except for local delivery. So you could see that was a perfect example of one of these roads that are posted 4,000 pounds and did allow for local delivery. So not to say that was enacted pursuant to this, because there are, as you'll see, other regulations that could apply there that road would have been on. But that's the kind of posting that they're going to be looking for when we say that all these roads have to be posted, and then the notice that local delivery is permitted. Vehicle and traffic laws 1640A5 and 1660A17 provide towns, cities, and villages to totally exclude trucks, commercial vehicles, tractor trailers, trailers, semi-trailer combinations from specific highways. Again, the language here is a little different with respect to local delivery. Again, this provision, just like the truck route provision, states that you shall not prohibit local delivery or pickup along the excluded highways. So again, this is less broad in scope than the truck route system, but broader in scope, because you can exclude all these vehicles from them, but you have to allow for local delivery and local pickup. 1648-20 and 1648-28, again, very similar regulation. This one, though, does state that you can limit the hours of operation on certain highways. Again, shall not prevent delivery or pickup along the excluded highways. So you'll notice that all of these provisions are very similar to one another. However, they're all somewhat distinct. They each have slightly different language that kind of sets forth what the various rights are there. And now here comes my favorite one, which is 1640A16, 1660A25. That allows local governments to adopt such other reasonable regulations that are related to traffic, as warranted by the local conditions and subject to the limitations contained in, and I put it in quotes because it's statutory language, the various laws of the state. So to recap, well, this one allows reasonable regulations as warranted by local conditions, subject to the limitations contained in various laws of the state. I view this as some pretty broad authority to adopt regulations, but not everybody will. What is a reasonable regulation? What regulations are unreasonable? That's one of the questions that you're going to come into. Whether the local conditions actually warrant the regulation is going to factor into whether or not it's going to be considered reasonable. And then, subject to the limitations contained in the various laws of the state, again, just saying that you can't, that this section of law is not designed to supersede any other inconsistent laws of the state, so you still are constrained. You don't have carte blanche to adopt whatever regulations you'd like. So just kind of tying this together into your local law authority here. You have your municipal home rule law authority that authorizes you to adopt local laws providing for the care and the use of the highway that are consistent with the general laws of the state. Vehicle and traffic law is a general law of the state that provides for some pretty specific regulations that you can adopt, but also allows you to adopt such other reasonable regulations. So when you read these two together, the Municipal Home Rule Law Authority and the Vehicle and Traffic Law Authority, particularly the reasonable regulations, you could have quite a bit of flexibility there. Now, again, we mentioned, do you have that much flexibility, or is it a little narrower? And different attorneys are going to have different opinions on how much weight should you put on this reasonable regulations provision of the Vehicle and Traffic Law in combination with your home rule authority. Some are going to say, well, not too much. Maybe we should, that's just kind of there to kind of fill in some of the gaps between these other authorities. Others are going to say, hey, let's take this and run with it. That's a local determination. We can't tell you where your municipality falls on that spectrum. It may have to deal with all sorts of different circumstances, not the least of which is going to be your municipality's appetite for either litigation or to take that kind of risk. So, and I mentioned earlier to pay attention to those two exceptions with the truck routes for the suitable connection and the suitable access to state highways and the local delivery requirements. And the reason I highlighted those is there was a recent decision in December that came out of the 4th Appellate Department. Now, the appellate divisions in New York State, there are 4 appellate courts, cover pretty large. The 3rd and 4th cover most of upstate New York and the entirety of where, for the most part, most of the gas drilling is going to be going. And the 4th Department, which covers mostly the western part of the state and up around some of the lakes, came out with a decision that said that although each of those vehicle and traffic law regulations are stated separately, you have to read them all together, and therefore that requirement that suitable connection be made to all state highways should be read so that if a local road provides access to a state highway, it cannot be included on a truck route, and that would apply to all of the regulations that we just went through, even where it wasn't expressly included. You'll notice that suitable connection language was only in the one provision with respect to truck routes, but the court has expanded that now to all of those various regulations. So that could cause some problems. If you remember Lynn's slide that showed where those routes were with the weak roads and the strong roads, if that's a weak route, but it gives access to a state highway, under this appellate division decision, you may have a difficult time excluding that from a truck route, from a designated truck route, even if other access is available. So now, again, that's right now limited. Well, that was a 4th Department decision. I believe it's going to be appealed, so there might be a little uncertainty there. But it's factors like that your town would need to consider when determining how far you want to go on a state road. You really have to kind of take a look at this. You really have to get into the weeds and figure out exactly what is the scope of our authority, what are we comfortable with. And because of that, Lynn mentioned that they have model local laws. I think that models are a great starting point, but every local law has to be looked at and determined on its own merits and as it applies to your local governments. So you don't want to just take one and adopt it standard, because it might not be the best fit for your town, because you may have different circumstances, you may have different personnel that could help enforce it. The conditions in your town are going to be different than those that adopted it. So that's again, this is a very broad overview of where your local law authority is, but we're going to talk about now damages. I mentioned earlier that preservation is the first part of this. The other half of the question is, well, damage will occur. How do we go about remediating it? What are our options? So the regulation of the traffic is going to be governed by the vehicle and traffic law. The construction, reconstruction, and repair of highways is governed by the highway law. Highway law, again, is a general law, so your local laws have to be consistent with that general law. And in a very popular case, the Court of Appeals has held that the highway law sets forth the mechanisms for financing the highways, and you cannot require a developer to, you cannot use impact fees assessed against particular developers to improve highways that are outside of their development. So impact fees are not necessarily they're not an authorized method of financing highway reconstruction, except if otherwise authorized by statute. However, Highway Law Section 320 provides some great language with respect to damages of the highway. It does state that whoever shall damage the highway by drawing a load of such a weight that will destroy or break or injure the surface of the improved highway, or by any other act, shall, for every offense, forfeit treble damages. Anybody know what treble damages is? 3 times. That's 3 times the amount of damage to the highway. So the highway law clearly sets forth the fact that those who intentionally damage the highways, or those who damage the highways by drawing across it a load of such a weight that injures it, could be liable for up to 3 times the amount of damage done.
It says just the surface of the road in that law, so that doesn't talk about anything under the surface, any kind of damages under the surface.
That's right. That's what the law says. There's been very little case law on this. One of the problems with the highway law is that a lot of it was written before there was vehicle traffic as we're seeing today. So there's not a whole lot of case law interpreting this section of law, but it does say the surface of law. And I would have to check. You'll notice that everywhere there's an ellipse, there's other language that was left out of this statute. So I'd want to take a look back and see what I cut out of there. Maybe there was something in there that would talk about that. But for the purpose of this slide, it does state just the surface.
Can damage be measured in loss of lifetime of the road?
Sure. I think that damage, we're going to get into calculating damages in just a moment, but I think that's certainly beyond my expertise. That's something that the engineers would be able to do. I think that damage is going to be quantifiable. Whatever you can quantify and support rationally should be sufficient. Now, quantifying that damage is going to be the hard part. And so, but yes, I think that damage could be loss of the lifetime of the road. It doesn't have to be complete destruction of the road. So, the one case that I have come across that interprets this section has some pretty strong language here. It states that the main purpose of the statute was to protect the highway for its ordinary use and to save the expense of frequent reconstruction. Penalties are visited upon those who lightly regard the rights of others. We think the rule of liability is to be applied whether the injury is the result of a single act or of several continuous related offenses against the statute. And I think that I like this language because this also contemplates, the statute states a load of such a weight, but it doesn't talk too much about the intermediate weights that are making extraordinarily frequent trips there. That's not in the statute. That's in the case law. That's in this case that says that the injury could be the result of a single act or of several continuous related offenses against the statute. So I think that you can actually, this is the Court of Appeals case that's going to allow you then to aggregate the number of trips combined with the weights of the vehicles, as Lynn didn't want to get into before, which I think is best measured by the easels, the equivalent single axle loads there. Once we get into the actual calculation of damages, I'm in way over my head because that's more of an engineering thing. I just know that, important parts I'm going to hit on in just a moment. So how do you incorporate this now into your local law, and what are the responsibilities for the damages? Well, highway law, you can say, again, general law of the state expressly makes damagers liable for the cost of repairs to the highways. The local law that implements that provision would be consistent with the highway law. And it's also, the last point there, the payment for damages caused under the highway are different than impact fees, requiring developers to make improvements to highways that are not part of their plans. There's a difference in causation. There's a difference in there's the fact that the highway law expressly allows for the damages to be recovered. So without going into all of the details, I think it's sufficient that damages are distinguishable from impact fees, and therefore the local law can talk about damages. So that's pretty much the overview of where your authority lies in state statute. You have your road use, your regulatory authority under the vehicle and traffic law. Your authority for remediation flows from the highway law provisions. But how do you tie these into local actions, local documents? And the two most common are going to be your road preservation local laws and your road use agreements. Just a couple of distinctions between local laws and agreements, and I believe Mark Sweeney, who just joined us, is going to get into a lot more on some of the road use agreement stuff. And I think that, again, there's going to be no right or wrong way to do this, but the two could work very well together in conjunction with one another. But local laws are a law. Validly enacted local law is going to have the same force and effect as a state statute. Compliance is mandatory. Folks don't get a say as to whether or not they want to comply with the local law or not, despite what they might tell you, despite what you might hear, or despite who they think they may be. If it's validly enacted local law, compliance is going to be mandatory. They don't have a say in the matter. And local laws can provide for its enforcement through civil and criminal penalties. Road use agreements, on the other hand, are more contractual in nature, and they're voluntarily entered into. You sit down with the entity that's going to be proposing the project, sponsoring a project, and you come to an agreement as to the terms and conditions of the use of the roadways, but it's voluntarily entered into. So that you have a little bit more flexibility to negotiate the contracts. One of the advantages of a road use agreement over local law is that it could be multi-jurisdictional. You can have a group working together to negotiate a singular road use agreement. Much harder to do, I think, for local law. So, but what are the basic elements of a local law? And again, this is a very truncated version because of the timing of this, but had to narrow it down. Some essential elements in tying all of these together. You want to have your definitions. A lot of these road use local laws are going to involve terms of art, phrases, stuff that you wouldn't ordinarily use in parlance, or something that may have a specific meaning in the local law itself. You want to make sure that any of these terms are clearly defined. You don't want to just throw out a phrase, high volume truck traffic, and then not provide any guidance as to what that is, who qualifies there. That's going to give you a real hard time enforcing that. You want to make sure that the local law clearly spells out any of these terms and clearly defines that. It also helps establish some of the scope of, some local laws will use the definitional section to help establish the scope and help interpret the scope of the document. One of the things you want to avoid when adopting these local laws is casting a net that's too wide. What's going to happen is you're going to capture a lot more truck traffic than you ever anticipated. If you have a permitting system in place, the permitting issuing authorities are going to be overburdened with the work, with the applications. You're not going to have the resources to go through all those permits. You're not going to have the resources to properly enforce. So you want to avoid casting a net too wide. You may also run into other issues, constitutional issues, prohibiting local delivery, all those kinds of things. So you want to avoid casting that net too wide. You also don't want to make it so narrow that it doesn't, in fact, do the job that it was designed or intended to do. So one of the first things you have to consider when adopting these local laws is what is the scope of the local law? What is it that we're looking to capture here? You can then get into your preservation measures, establishing your truck routes. You know, and again, this is where some of Lynn's engineering data will come in. Ascertain the condition of your roads, either on the functional or structural analysis, but get a baseline as to what roads can withstand what traffic. That's going to be a great starting point, because that'll help you then establish what the truck routes should be, and what conditions might be needed for the permitting there. Remedial measures. Another big substantive component of your local laws. You want to make sure that you have in place remedial measures that provide for security, insurance. You might see maintenance bonds being required. Again, these are something that, as part of a permitting process, a developer would put up and say, here's a maintenance bond, and then you can draw against that when it comes time to remedy the damage once you've ascertained what that damage was. They should have appropriate insurance, and perhaps add the town as, an additional insured, especially if they're going to be doing any of the work on road reconstruction or reconstruction. And then the last basic element is going to be enforcement. So, all right. So again, when you talk about our preventative measures and the restrictions that you can have on truck traffic, certainly weight and dimensional requirements, these were included in the vehicle and traffic law regulations that we saw. So you do have authority by your local law to establish weight and dimensional requirements that we discussed, and to have the permanent and temporary exclusions. When you combine those two with your reasonable regulations and some of the express authority there, you also then have the authority to permit trucks who would otherwise be in excess or in violation of those. Permitting could be, again, the local law should clearly spell out, if you're going to issue permits, the law should clearly spell out what the permitting process is going to be. Who's going to be required to obtain permits? Who issues the permits? Is it going to be the highway superintendent? Is it going to be the town board? Is the town board the most practical body to do it if they're only going to be meeting once a month and it takes an action on the town board to issue them, depending on the volume of traffic that you're expecting? That might not be the most practical way to do it. And then you have to figure out what the terms and conditions of the permits are going to be. And again, these you can get into a whole 1-hour presentation just on what the terms and conditions of the permits are. And I do think that a lot of this is going to carry over, and Mark's going to talk about, again, what should be incorporated in road use, what kind of road use agreements. And I think that a lot of the standards are going to be essentially the same. You're going to be looking to accomplish the same goals, I think, through both the local law and the road use agreement. So there is kind of a lot of overlap there in some of the details. The remedial measures. And this is one area that I've heard that a lot of towns are perhaps most interested in is, how do we make sure that we're protected, that we're not absorbing the costs of all the damage that's done here? So again, I mentioned before, insurance, bonds, letters of credit. Those are all some of the tools that you're starting to see pop up in these local laws. One of the issues, and you heard Lynn mention benchmarking, and I think that establishing the baseline of the road prior to any of the use is going to be essential to being able to then calculate the damages, because that's going to be your starting point. If you can't quantify what the condition of the road was prior to the heavy truck traffic that it was exposed to, you're going to have a very difficult time then attributing that damage to the use of those vehicles. So you want to make sure that whatever as part of the remedial measures here, that you have that baseline established. Again, whether it's through the functional method, if you have photographic evidence or videographic evidence of just the functional conditions of the road. I've heard some folks, some highway superintendents, who have been having their crews kind of just drive down the roads with video cameras, just kind of documenting, this is what the road looks like. Here are some of the cracks. So at a minimum, you have that functional, you get to see the functional analysis, but very important to establish that baseline. Once you have that established, again, you have to establish what are going to be the triggers for accessing the insurance or the maintenance bonds, what the amounts are, what is a sufficient amount. And again, these are some of the things where boilerplate language may not necessarily work. So the one size fits all is it's not a good method, but you can certainly use another example as a starting point, but you got to make sure that when you're crafting these local laws that you then bring them down and make them applicable to your communities. When it comes to the construction or reconstruction of the road, who's going to perform the work? Is it going to be your crew? Is it going to be their crew? You're going to have to establish, especially if it's going to be somebody else, you have to establish the standards to which you want the road to be rebuilt. I'm not sure how many have this problem, but I've heard that there could be problems with super adequacy, where you have a local road that was then built up, expanded, widened, paved, so that the heavy trucks can get to and from the site easily enough. And then when you're done, now you're left with the two-lane highway when you used to have an oil and stone road there. And now you have to absorb the cost of repairing that. So, what are the standards that these roads are going to be constructed or reconstructed to, and what are you going to be left with at the end? Again, these are all considerations that you have to keep in mind when you're going through these agreements, when you're going through these local laws here. And unfortunately, at the timing of this presentation, I don't have the time to really kind of get down in there. But again, I think that's something that's certainly better done on a more local level. Sit down with your highway superintendent, sit down with your town boards, your town attorneys, and try to iron out some of these issues as you're getting the process started here. And then enforcement. Who is going to be enforcing the law? I mean, enforcement actually will start, effective enforcement is going to start at the very beginning, before any trucks even enter the road. And that's because if nobody's aware of your local law requirements, it's going to be very difficult to enforce the fact that they get a permit or to enforce the truck routes. Make sure that you have them posted and that everybody's on notice. With the gas drilling and any of the heavy truck traffic associated with fracking, good opportunity, because your DEC is going to notify your town of every drilling permit that is, in fact, applied for in their office. That would be a great time to kind of get out in front of the applicant and let them know that you have these road preservation laws and that you're willing to enter into road use agreements with them. Take the time. And that's your first step in enforcement, is before they've even done anything within the town. Don't wait to enforce until it's too late, till the roads are damaged. But you can provide for civil remedies such as the repair of the roads. And local law authority, you do have the authority to enforce criminal penalties for those who would either intentionally or willfully violate the local laws as well. But usually the enforcement is going to be the cooperation of a group of officials. You're going to have your highway superintendent involved, you're going to have your codes enforcement officer involved, and you're going to have your town board involved, all in the enforcement of the local laws. But again, it all is going to start with putting them on notice, letting them know what the established truck routes are, because the goal of these are to preserve your local roads. I think that if you can preserve the local roads and minimize the damage, everybody's all in a better spot than if trying to then have to recover and get the roads reconstructed and repaired. So, and then my time is pretty much up, but the again, road use agreements are going to involve a lot of the same considerations, but Mark Sweeney is going to be talking about that after the break. So I have time for maybe one or two questions. If yes.
Is there any distinction made between road use for a development thing and somebody's going to be using the roads continuously all the time, like agriculture? Or put another way, has anybody set up road use agreements for routine operation of dairy farms where you have quite large loads sometimes?
I have not seen routine road use agreements for routine operations of dairy farms. I know Mark has done with them in the wind industry. My concern with applying some of these principles to continuing operations of dairy farms, you did see that you always have to allow local pickup and delivery of merchandise and property, and I think that once you start restricting the local pickup and delivery, if the farm is off that town road, all the dairy trucks coming in and out are going to be either picking up milk or delivering it from the site. So that could be,
or picking up manure and delivering it somewhere else.
yeah, and so that could be, and that would be considered, I believe, pick up and delivery, and that could interfere with interstate commerce as well. So that you have to be very careful when you're applying it there. This is not designed, in my opinion, for the day-to-day activities within the town.
We're going to have plenty of time to ask Mike questions after Mark Sweeney has had a chance. So Mike will be there. Where we are right now is we've sat through a lot of background information about how highways are built and how roads, highway law and road law works. So now we have something to think about. Think about your questions, because many of you have already started working on these issues. And how do you, what you feel and what's happening in your town, how is it being impacted by what you've heard today? That's what this is about. So the last hour will be for that. Thank you. Enjoy your break.